On the agenda, advisory opinion 2022-1 relates to the prize from convention raffle. Right before that, I would like to go over to Mr. Elliman and see if we would like to discuss some of the discussions, open items we've had regarding open meeting laws and executive sessions. I think it's best to have some clarity on that for everybody's clarity purposes.
Sure. So it's up to the board whether the board would like to have a motion to go into executive session. And the reason would be to receive attorney-client communications, specifically legal opinion and recommendations regarding the Board of Ethics, the scope of the work for the Board of Ethics, and the law concerning public officers law under the open meetings law, as well as advisory opinions issued by the New York State Committee on Open Government. That can certainly, there's no requirement that we go into executive session to have that conversation. But it's the privilege of the board, if someone were to make a motion that was seconded, to vote on whether to go into executive session for that purpose.
I don't think we need to go into the executive session, just my opinion, unless any other members agree, disagree. No? All right, Mr. Elliman, I think we should just be able to discuss just the outline of what's within the scope.
Sure, certainly. So under open meetings law, which is, I'm going to move this microphone to make sure I'm clear on the record. Under Public Officers Law, Section 102, subsection 2, it provides the definition of what a public body is. And I've previously provided this board with the legal opinion that the Board of Ethics does not constitute a public body for the purposes of the open meetings law. So specifically, part of the definition of a public body under Section 102 of the Public Officers Law addresses that the body or the public body is created or appointed to perform a necessary function in the decision-making process for which a quorum is required in order to conduct public business. It also defines what a necessary function means in the decision-making process. And it states a necessary function in the decision-making process shall not include the provision of recommendations or guidance, which is purely advisory, and which does not require further action by the state or agency or department thereof or public corporation. The core functions of the Board of Ethics as provided for by local law number 6 consists of providing advisory, and the standing rules and procedures for this board consist of providing advisory opinions, receiving, reviewing, and providing advisory opinions on written sworn complaints, and reviewing filed financial disclosure statements, and providing any advisory statements to the Board of Supervisors or the chairman of the Board of Supervisors concerning those financial disclosure statements. When the board is operating within its core areas, which are those, primarily those 3, they're acting it's my legal opinion that they're acting in an advisory capacity. The Committee on Open Government has looked at and reviewed the matter of advisory opinions. And the last opinion that was issued by the Committee on Open Government concerning a public body that acts in an advisory capacity was issued January 11th, 2010. It's OML-AO-4848. And in part, that decision, that opinion rather, also referenced that there are several judicial decisions in the state of New York which indicate generally that advisory bodies that have no power to take final action fall outside the scope of the open meetings law. Also goes on to state, as stated in those decisions, it has long been held that the mere giving of advice, even about governmental matters, is not itself a governmental function. And it goes on to cite a number of cases in support of that position. In that case, they're not talking about a board of ethics. They're talking about a governor's task force on public employee retirement health care benefits. But the executive order which created that task force did not provide that task force the ability to make any decisions, only the ability to make recommendations or provide advice or advisory opinions to the persons or entities that would be making a final decision. So in a nutshell, that's the legal underpinning for the reason why on a previous occasion I gave the legal opinion that this board, when working in those three core areas, falls outside the scope of the open meetings law. On the flip side, when we were addressing standing rules and the process of procedure that this board was going to enact to govern itself, that did not necessarily, or it certainly wasn't as clear cut that that was advisory in nature, as the board was creating rules of how they were going to operate and work. And for that reason, my recommendation was that that be done on the record in an open meeting, which is why we had in part the meeting in March and then the April 20th meeting of 2022 on the standing rules. Additionally, one of the other functions or duties provided to the Board of Ethics under the local law is, upon request of the Board of Supervisors, making recommendations to the board for modifications, additions, changes, basically, to the rules, to the Code of Ethics for the county. And even though the board would only be acting in an advisory capacity, that does seem to be a little more closer to how government functions and operates. And the board would have the option to determine whether to have that meeting as part of an open meeting or not. When we get to that point and upon further legal research, I might change the opinion, but I'm leaning more towards that I would make a recommendation to do that as part of a public meeting, because you're discussing, again, nuts and bolts of how the system works and what, in your opinions, does not work under current rules and what can be changed in the current code of ethics, which seems to sound more like the kind of conversation that should be covered or presented through an open meeting. And then you have the practical concern and issue that should the board decide to operate under the open meetings law, that the board should have to provide a basis to go into executive session in order to cover those three core areas of responsibility, specifically addressing sworn complaints, issuing advisory opinions, and reviewing the sufficiency and content of financial disclosure statements. The bases to go into executive session are also provided by the Public Officers Law. And there's a number of different reasons stated in the statute. Many of which have no application to the Board of Ethics. The one that appears to potentially apply or may apply is when the subject matter is the medical, financial, credit, or employment history of a particular person or corporation, which may or may not be part of a discussion for purposes of an advisory opinion or possibly a complaint. But more specifically, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. Again, the concern is the quote unquote final decision or final recommendation by this Board of Ethics does not necessarily result or lead to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. But that would seem to be a basis that would be the closest basis for this board to use to go into executive session to have the type of conversation, whether it's on a sworn written complaint or an advisory opinion that's requested, should the board proceed in the open meetings format. I'm a little unclear even today how the board would proceed other than what has been done over the last one or two meetings, which is we call an open meeting, we deal and address matters that are part of the open meeting. To the degree there may be something for executive session, there would be potentially a motion that the board would make to go in, but you would then come out and then adjourn the meeting. And after the meeting, because the subject matter is outside the scope of open meetings law, there's a more full, frank, and complete discussion of particular matters that are advisory in nature. For example, the advisory opinion 2022-2, which has been made public as required by the Board of Ethics by a unanimous vote. But the discussion of that matter and the deliberating process to determine a recommendation from the board was not done in the open meeting format. It was not done in the executive session. It was done outside of the open meeting law because the subject matter was not part of the decision-making process for the county. It was merely an advisory opinion that the board was providing to the individual who requested it. So that's a lot of talking to start the meeting. I don't know if there's any questions about the content. I know it's a lot of legal, has the potential to be a lot of legal ease. And I've said this to some of the committees before. I don't take any position on which way the board seeks to go today, tomorrow, at a meeting next month, whether it's by topic. But to the degree that there may be some consistency with how the board addresses an advisory opinion, a sworn statement, or the review of financial disclosure statements, there may be some responses that flow from that, whether it's a willingness to provide or request an advisory opinion, because there's can be some basis or belief in the confidentiality of that request, or in the case of a sworn complaint, the ability to do the initial work on that complaint outside of the open meeting format to ensure confidentiality and to protect the interests of the individual who filed the complaint, as well as the individual who is arguably charged with some form of an ethical violation. So those would be all the kind of factors to weigh broadly, but also on any individual matter in determining how you would proceed. The practical difficulty is I can't create a meeting in order to get the board's opinion on a particular matter that may come up tomorrow and need to be addressed next week. as far as whether it should be dealt with on an open meeting format, or if it's outside the open meetings law, because it's going to be, because the committee deems it's advisory in nature and wants to proceed that way. So subject to any questions you guys may have.
May I ask a question? The Committee on Open Government, what is that body? What is their function?
Sure, that's a great question. The Committee on Open Government is created under the Public Officers Law. They have a number of responsibilities, one of which is to report back whenever there's amendments to the open meetings law to the legislature and to provide a report on the impact and effect. They also do, I don't want to sell them short, they do quite a few things. They're created by statute. They also have public hearings on the open meetings law to get public opinion regarding the application of the open meetings law. One of their other core requirements, and they really cover two areas, not just open meetings, but FOIL, which is also under the Public Officers Law. But one of their core activities is receiving requests for advisory opinions and then preparing and publishing those advisory opinions on, in their opinion, how FOIL should operate and how the open meetings law should operate.
So this is an agency designed to assist governmental bodies in addressing transparency in government.
It's
Correct.
a committee under the Department of State for the state of New York. Yes, that issues opinions. Opinions are not binding. They're usually limited in their scope to the request that they receive. And they're very clear in the first two sentences of every opinion that basically says that they're authorized to issue advisory opinions and that the opinions are based solely on the information that's presented in the correspondence received from the individual.
But their advisory opinion should be given deference.
I do, certainly.
And the next question is, I'm sorry, I forgot what it was. Come back to me. Oh, I'm sorry, I remember what it was. In the decisions cited by the advisory opinion, were there reasons discussed why advisory, governmental bodies that only give advisory opinions, why those should not be subject to open meetings law?
What it states is it references that there are several judicial opinions which indicate generally that advisory bodies, other than those consisting of members of a particular governing body that have no power to take final action, fall outside the scope of the open meetings law. So let me try to explain that a little bit because it's not necessarily easy to understand. So in Warren County, we have a board of supervisors. And under the board of supervisors, there's a number of standing committees that exist. The standing committees are all populated by members of the board of supervisors. What they're saying is here, they're discussing advisory bodies other than those consisting of members of a particular governing body. So for example, the Board of Ethics, there's no member of the Board of Ethics who's a member of the Board of Supervisors, the governing body for the county. And that when those type of bodies have no power to take final action, they fall outside the scope of the open meetings. Now, the 2010 opinion, which is interesting, does not directly reference the language from the statute. And I can't tell you if that statute, that's the last opinion that's noted on their website regarding advisory bodies. And there's a number of opinions before that. But the current version of the open meetings law statute section 102, when it defines what a public body is, because that's the key term to determine whether the open meetings law applies, specifically states in there that a necessary function in the decision-making process shall not include the provision of recommendations or guidance which is purely advisory and which does not require further action by the state or agency or department thereof. So good, bad, or indifferent, the local law that created the Board of Ethics provided the Board of Ethics the ability to do certain things, but does not require the Board of Supervisors to therefore take action should the Board of Ethics issue an advisory opinion, issue a determination on a complaint, or provide information regarding one or more financial disclosure statements.
On the open meetings law page, I just pulled it up and there's a section called Board of Ethics. I don't know if
Yes.
you looked at that, and it says, where did it say? It says that it is let me see if I can find the paragraph I want to reference.
The only suggestion and recommendation is we have to be careful on the date and what we're pulling from those and what the issue was that was presented.
Well, this isn't an advisory opinion. This is just a section. If you go to the open meeting law page, and then it says overview. Okay, then there's advisory opinions, case law summaries, model rules for public bodies. And then if you go down, there's a section that says boards of ethics. And okay, as indicated earlier, the general municipal law states that a board of ethics renders advisory opinions, and questions frequently arise concerning the status of advisory bodies under the open meetings law. However, since boards of ethics are creations of and carry out their functions based on statutory direction, they clearly constitute public bodies required to comply with the open meeting law.
And I think that's in direct conflict with the open meetings law.
Well, this is, I mean, I'll leave
I'd
it.
have to look at that one particular provision of where they're getting that from, that to provide that determination on it.
Would specifically,
Some boards of ethics may have more power than just advisory roles. I understand from what you read, they said merely advisory, but I'll have to get back to the board on that piece.
would it be of value to ask for an advisory opinion specifically with respect to our board and our rules?
We could, it would take some time probably to get it, but if a majority of the board wanted to do that, we could certainly draft a letter and send it to the Committee on Open Government.
So county boards of ethics are derived from the county board of supervisors pursuant to the resolution and how they want it to be. So,
And from general municipal law.
so board of
Requires
ethics and
their
different,
creation.
so yeah, so board of ethics, their function may be different in different counties.
They could potentially be different. They don't necessarily have, they can't do less than what's required by the general municipal law, Article 18. But the powers they have is all derived from the board. It could be the legislature or the board of supervisors, depending on the governing body for the county.
So a couple of quick questions. I know you mentioned sworn statements and complaints. Now, we have been following, or we should be following, going into executive session to discuss any of the sworn complaints. What happens if it is a non-sworn complaint? Now, in theory, we should still be discussing that if we are discussing that in an executive session, correct?
The unsworn complaint procedure is laid out in the standing rules that the Board of Ethics enacted. So should the board get a unsworn a document that basically claims to be a complaint, but it's not sworn and doesn't meet the requirements of the Board of Ethics. The board doesn't have to take any action on that. It's up to the chairman to make a determination on what, if any, act, whether it complies with the standing rules and is a sworn complaint. To the degree that the Board of Ethics received a document as part of the agenda for today, it was not provided because it was a sworn complaint, but because to provide the members of the board an opportunity to discuss the contents and what, if any, action the board wants to take regarding the contents of that document. But it wasn't provided as a sworn complaint for the board to take action on.
Okay, so now the point is,
And I guess I just wanted to back up. It's still an open question on whether the board would proceed in executive session or proceed outside of the open meetings law. Although I think I owe the board a clearer statement based on what was read by board member Palmer from the website on the open meetings or committee on open meetings.
now in the process of discussing the process of coming up with an advisory opinion of any sort, I think the clear distinction that we are looking for advice on is whether it's a discussion, decision, or any kind of, I would say, discussion and decisions on providing advisory opinions. When is it deemed necessary to have an executive session versus a, I would call it private meeting per se, for business purposes. However, that is not published or no minutes are provided for it. So I just want to sort of clarify, when is it okay for us to meet without an executive session?
All right, let me start maybe at the beginning and kind of walk through that. So the Board of Ethics has two potential options. One, under the open meetings law, is to schedule a meeting, provide advance notice of that meeting, and then to appear at the designated time and place to conduct the meeting. Under that scenario, there may be subjects that the board addresses that the board may wish. They do not have to. There's no requirement under state law that any public body go into executive session, but executive session is available for very specific enumerated reasons under the statute. As I stated earlier, under that process and procedure, the one potential basis for this board to go into executive session would be for matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation, which means that a majority of the board, upon a motion to go into executive session, would have to approve the executive session, believing that that exception to the open meetings rule applies. The second potential alternative, which I need to provide further information to the board on, is the ability of the board, when dealing with an advisory matter only, conducting a meeting outside the open meetings law because it's advisory in nature. That's something I will need to look further at and we'll follow up with the board on. So looking at the agenda today, there's 2022-1. I cannot, if asked for a legal opinion of whether the subject matter for advisory opinion 2022-1 falls within an exception to the open meetings law, meaning a basis to go into executive session, I cannot derive that or come to that conclusion because the subject matter, the advisory opinion, does not appear, and really this is a determination for the board to make in voting, but it does not appear to involve a matter leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person. It's seeking an opinion on what to do with a particular type of prize from a won by a particular employee who attended a convention as a result of a raffle.
And this opinion has already been made public, right?
No, not on 2022-1.
Okay.
No, because the board has not discussed it, deliberated it, reviewed it against the code of ethics, discussed the options and availability of options and whether more information is needed or they have sufficient information to come to a determination sufficient so that Attorney Terwilliger, because I'm going to have to step away soon, can prepare a draft opinion for the board's review and future approval and signature. As for the other item on the agenda for today, the financial disclosure statement review. If the committee is acting under the open meetings law, I'm having difficulty determining how the review of financial disclosure statements falls under the exception that permits executive session. But it's my understanding that the financial disclosure statements generally in the state of New York are not reviewed in public sessions for public viewing as part of an open meeting. So, and then the third and last item on the agenda, which I'll hit briefly, is the document that's referred to. And as the committee has reviewed the document, it does reference individual names. And there may be some argument that should the board determine to continue in the open meeting format, that discussion would potentially deal with matters leading to appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person. Not putting any weight on the allegations, just merely the type of allegations that are in the document. And again, the document was provided more for informational purposes for the committee to determine what, if any, actions they wanted to take. And also one of the reasons why we brought down copies of all the financial disclosure affidavits, so the Board of Ethics would have them available to review.
I thought that reviewing financial records of employees was a valid reason to go into executive session. financial, medical histories.
It says the medical, financial, credit, or employment history of a particular person or corporation. I guess if you're going to consider it a financial history, which might be as much, it might touch the edges of that, kind of like the document might touch the edges of the matter leading to promotion, discipline, suspension, or dismissal. But again, that would be an issue for the board to consider and vote on as part of a motion for executive session. So with that said, and, subject to any additional questions for the open meeting portion, I guess the question is whether any member of the board wants to make a motion to go into executive session. Again, the advisory opinion, I think is somewhat problematic under the rule. But executive session for purposes of the document and review and discussion of financial disclosure statements does appear to be more in line with the executive session, if that's the decision of the board. And I mentioned it to the chair. I have a court appearance at 2 o'clock that I need to shortly, which I did not have control over. And First Assistant Robert Twilliger will take over for me in my absence. So the financial disclosure statements are on the chair behind this pillar in the notebooks. So unless there's any questions I may answer, I am going to take leave of the board.
You had a question real quick. Go ahead.
I can ask
Okay.
the other attorney if you need to leave. It's fine.
Why don't you ask me and then I'll head out.
Okay. I think if we're discussing an advisory opinion that an employee asks based on, can I do this if I'm an employee here? It has to do with their employment record, which means we can go into executive session. So, I mean, I definitely want to hear your clarification after you review the statement, but I don't see any reason why we couldn't operate under open meetings law and still protect confidentiality by going into executive session for valid reasons.
As long as it falls under that one primary area and the board determines that it legitimately falls in that one primary area, that's really the determination for the board
But if it doesn't,
to make. I'm not giving what the question is.
I guess my question was, if we're discussing an advisory opinion, like in the one that's listed under A here,
Mhm.
that has to do with the person's, I think it has to do with the person's employment history. They're saying, as an employee, can I do this thing, this activity? Can I accept this prize?
But it has to be promotion, demotion, discipline, et cetera. And at least from our preliminary discussions about that allegation, we believe that there was nothing wrong done. So it's not promotion, it's not discipline, it's not.
No, but it affects those things. The person's asking for an opinion.
But we
I'm gonna
can't,
step
we
out.
don't
Thank
have
you
any
so much.
control
Thank you,
over
Larry.
what happens to her position as the board. I see
Even
what you're
even
saying.
if we thought that it was the worst violation ever, we can't
It's up to the
penalize
board,
her.
it's up to the board of supervisors to make that determination.
And that's the thing, is that we give advice and that's it.
I don't disagree about the executive session portion. I don't disagree about that.
I completely disagree. Is that the law says is that we're not subject to open meetings law. That's there for a reason. There were very smart people that came up with these decisions about what's subject to open meeting and what's not. And somehow the five of us are saying, well, we know better, we should be open meetings. And there's reasons why advisory opinions are private, is that the chief of staff tells the United States president what to do. That's not public. That's not subject to open meeting. And there's a reason for that, because they don't want the advice affected by public pressure. So when the chief of staff of a senator's office or whatever gives advice to the senator, that's not public. And there's a reason for that. So the advice that's given is not subject to public scrutiny and affected by public pressure and whatever else. And all we do is give advice.
But that's not a public body with a quorum. That's one person who's an advisor.
Their entire staff or whomever.
I think, I mean, I hear what you're saying. I would like clarification on that document that I read, which is on the front page when you go to the open meetings law page, and it's titled Board of Ethics.
And that's why I asked about the why it's, why the JCOP, or I'm sorry, the Committee on Open Government and the judicial decisions talked about advisory boards not required to be subject to open meetings, what the why behind that is, because I think that's important for us to just say, well, we're going to choose to be an open meeting, even though we're not required to be, is ignoring those whys.
I think we should leave that as a pending item from the attorney's office for further guidance. I just want to quickly clarify one more thing, Brian, and I agree with your discussion and what Diana is saying. I think the issue is, should we at least make sure that every meeting that we hold are announced, and whether we go into executive session and discuss certain aspects, the decision or the recommendations can be subject to us putting down as minutes of the meeting. But I think the biggest challenge is we are not going to have meetings without them being, published and having minutes for those. Does that make sense? I mean, I'm not disputing the fact that we should be discussing this in open meetings. We should technically still be discussing it in a sensitive matter within an executive session, but at least to make sure that all the meetings are notified and documented for.
I think that that's still blending the rules between the two and creates questions. Whereas, as Larry said, there's two options. One is we're a open meetings law required meeting, and we have to follow all of the open law meeting requirements of notice and executive session. And the other is we're not a body subject to open meeting laws, and executive session doesn't even exist in this other side.
Correct.
You know what I mean? So I think it's dangerous to blend those two things and talk about. So I mean, I think we have to pick a path.
Definitely. No, we would definitely wait for the opinion from the attorney's office to make sure we are on the right path and there's clarity for what we are trying to do.
But another factor is the chilling effect of it being an open meetings law is that people will be concerned about reporting things to the Board of Ethics if they think what they report is going to ultimately be made public.
I agree.
So your opinion is that, well, not your opinion, but you're saying that, so right now, for instance, we're in a public forum, we're live on YouTube. You're saying that we shouldn't or cannot move into an executive session, so everything that we discuss should be public at all times?
No, the opposite, that we're not subject to open meetings laws, so we shouldn't even have to be on YouTube.
I see what you're saying.
But the problem is that if we are going to choose to be a board that is subject to open meetings laws, even though we're not required by statute to be, then we have to follow all of the open meeting laws to a T.
And I believe we are subject to open meeting law, and I'm open to being wrong. I want to hear the clarification after that document is read. So I wouldn't be comfortable just saying, yes, let's go that direction, but I'm not foreseeing that what I'm saying is correct. I would really like to hear clarification.
Which makes sense. I
Yeah.
think.
Mr. Chairman, if I may make a motion to table this conversation until we have more information from Attorney Usi.
I'll make a motion from Attorney Elman.
Elman, I'm sorry. Excuse me, sorry. Sorry, Bob.
Yeah, and we will do that as soon as we get clarification and clarity from the attorney's office.
Is that, are you good with that?
I'm good with that.
Okay, okay.
All right, so we will table this for right now till we hear more from the attorney's office.
I think
further
that's
discussion.
fair. Are you good with that? You good with,
Yeah, I, when Diana read that leads you to think differently. I mean, before
Agreed,
that,
yeah. I think
I agree with what Larry said and what Brian echoed about if you're not subject to it, then don't do it.
Right. And I think it's important to be transparent and for us to dive into every avenue, I just think right here, right now, we don't have all the answers to be able to.
All right, so as we table that, we still have to move forward with the unfinished business we have on the agenda, which is the advisory opinion 2022-1 which is related to the prize from the convention raffle. I would open this up to the board to see if they would like to get into an executive session to discuss this, since we already have it on the agenda.
But it's-
Um,
Mr. Chairman, so my understanding that we did discuss this matter, not in an executive session, but at a latter meeting, or excuse me, a prior meeting that we had in April. Am I mistaken in
No,
that?
you're right, and that's why I had questioned Mr. Elman about, was this opinion made public? And my understanding is that there is more discussion to be had on that, which I do not have information on, which is why I recommended or defer to the board to see if we would like to go into the executive session to finish that discussion, because we don't have further information on that.
So from what we've discussed previously, there's no new information, or
No.
there's nothing.
There is
new?
none that we are aware of, and from the last discussion we had, the board had come to a conclusion that we were not going to take any action. So again, this being on the agenda gave me a reason to believe there is more information to be discussed. And if there is none, we can certainly move on without discussing further on this.
Should we discuss whether or not we want to make that? I know that advisory opinion 2022-2, we voted to make public. Is that a conversation, Mr. Chairman, that you wish to have to make advisory opinion 2022-1 public?
Not without knowing if there's any additional information coming after our past discussion. I mean, again, we as a board had agreed to not have anything to do with, or any recommendations, or we're going to act on that. So I don't think we need to make it public unless there is any additional information, which I'm not aware of.
Okay. I mean, I don't see a reason to go into executive session about it. Do you? Anybody?
Especially because Attorney Elman said it was dubious whether we even could.
Right,
So why-
exactly. Yeah, that's what I'm.
So why even touch it?
Do we have any other additional information on the topic if we would like to discuss without going into an executive session, the advisory opinion on 2022-1?
I do not have any additional information on it. I don't know if any members of the board or the board has any information on it.
Okay, so if we don't have any other information on that, the unfinished business for the advisory opinion 2022-1 related to the prize from the convention raffle, we will dismiss that as is right now until we hear anything further on that. Would somebody like to make a motion on that to dismiss that?
I'll make a motion to dismiss that, Chairman.
I'll second it.
Thank you. That brings us to new business. And we have two items in here, a document which was circulated amongst us dated May 13, 2022, and B, which is a financial disclosure statement review. The first one is a point of discussion, the document that had come to us, which I think should be discussed. The financial disclosure statement reviews are something we put on the agenda to make sure that if we had any more questions or wanted to review further, we would have that open today.
Mr. Chairman, do we know whether the document under new business dated May 13, 2022, which we have all seen, was sent to us? Was that a sworn?
It was it was not a sworn statement or not a sworn complaint.
That's not a sworn complaint. Okay.
So
Sorry, go ahead.
So the question is, do we want to go into executive session to discuss that?
And this is why, because Attorney Elman mentioned that it specifies individual names on the complaint, I think it should be discussed in an executive session, even though we don't take any action or don't have any recommendations or advisory opinions. That discussion in theory should happen in an executive session.
And until we know more based upon what we've tabled from our conversations
Correct. I mean,
earlier.
the very fact is we may end up discussing that document and may agree that there is no further action to be taken. But if there is further action to be taken, we can defer to Attorney Elman for further review, pending their opinion on our outgoing our outstanding issue as of today.
Right.
Mr. Chairman. Based on the prior discussion, it's my assumption that we would be going into executive session to discuss the medical, financial credit, or employment history of a particular person or corporation, or matters leading to the employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation.
Yes.
Mr. Chairman, if I may make a motion to move into executive session to discuss the new business.
I'll second that as well. We,
Mr. Chair, one,
yes,
it is
please.
within the board's discretion to determine which staff outside of the board you would like to be in executive session. So if, and no offense if it doesn't include me.
I'll open it up for voting. If anybody would like to make a motion.
I'm fine with, what your first name again, sir?
I'm Robert.
Robert. Bob. I'm fine with Attorney Moore and, or, geez, Administrator Moore and Attorney, not Bob Usi, but Bob, staying for the portion of executive session, if that's okay.
I'll second that.
All right, thank you. So yes, we will have you in the executive session, Mr. Moore, and then Attorney Bob as well. So we are going into an executive session to discuss the new business document dated May 30, 2022.